Give me an example of a tort exception to the at will. Maybe fraud, all right? And we'll talk about what a fraud element is, but understand that fraud basically is this, that at the time I make a statement, I didn't mean it, okay? Now, we're going to get a lot more detail on that in a later class period, but for our purposes right now, just believe that fraud is, I make a statement that I don't intend to follow through on, okay? So, Amanda, you come to work for me, you're in Missouri, but I've got a job for you in Chicago. Let's go back to our Missouri, Chicago, okay? And you come and interview with me. And I say to you, come here, this will be a great job for you. And you say, look, Greg, I don't want to come all the way to Chicago and work for you if you're going to turn around and terminate me 5 days later. And I go, Amanda, I would never think, look at me, who am I? I would never do anything like that, right? And the second you walk out the room, I go, God, Amanda, she's going to come all the way out here. We're going to just ruin her life just for the sake of having fun with her, right? Okay. So at that point, I did not have any intention of hiring you. You relied on that. We may have a fraud situation. In that case, fraud is a tort, and in that situation, I would not be able to fire you. Okay? Does that make sense? We may talk about some others as we go along in a later class. All right. Any other questions? Those are good questions. Yeah.
Wouldn't it be hard to prove in an at-will employment? I mean, because you don't have to have a reason to fire.
Right. Torts we throw it out there because there are some very limited situations where torts can be an exception to the at-will doctrine. But for the most part, how are you going to prove it? And that's why I say, really what you get into, the first three that we talk about, those are your biggies. The implied covenant of good faith, you may win some on that, but not many. Torts, probably very little. But there are exceptions to the employment at will. Your main exceptions are going to be your contract, statutory, or public policy. Okay? And in fact, after tonight, we probably won't talk anymore about the implied covenant of good faith or torts as an exception to the at-will doctrine because it's very hard to prove. And most of them are within those top three tiers that we talk about. All right. Okay, last class period we were talking about the exceptions to the employment at will doctrine. We kind of concluded with those last with those 5 exceptions: contractual, statutory, public policy, implied covenant of good faith, and torts. Now, for this class period, we want to focus more on this whole idea of torts and the workplace. All right, torts and the workplace. And again, remember, torts are predicated on the notion of what? Where contract is predicated on an agreement, torts are predicated on what? Duty. Okay. Torts are predicated on the notion that I have a duty to do something, that I have violated that duty, and as a result, somebody has been harmed. All right. In your let's take it out of the employment arena altogether. I have a duty to stop at a stop sign. I don't stop at a stop sign. I run it, and somebody gets harmed because I run it. All right. Committed a tort. Now, if nobody is there when I run that stop sign, can anybody sue me for running that stop sign? No, because even though there was nobody there that I owed that duty to, and nobody's been damaged, all right? So torts are based on this concept that there's a duty, that I violated that duty, and that as a result, somebody has been harmed. There is a theory out there, I don't want to spend hardly any time on it, but I'll throw it out there as a tort, that there is what we call abusive discharge, okay? That there is abusive discharge. That would be a tort, if you will, okay? In order to show that, I got to show what? That I had a duty not to discharge the person or to do it the right way, okay? That I breached that duty and that injury resulted. There are some cases that talk about it. I don't know of a single case in any jurisdiction that has actually found an employee to be terminated because of an abusive discharge. But I guess you could be so outrageous that you are. You invite somebody's family and friends to a party. Let's say you're getting ready to fire. Amanda, I'm going to fire you. We've already picked on you, okay? So I'm going to fire Amanda. And I'm cruel to Amanda, all right? And so I think, hey, Amanda's having a birthday. Amanda's going to have a birthday coming up, and so I'm going to throw a surprise birthday for Amanda. And I invite her, and I get close friends to Amanda. I invite her friends, and I invite her family, and I invite everybody. I put this big shindig on at Big Whiskey's or wherever I want to have this party. And when she gets there, I put on the big screen, Amanda, you're fired. Okay? Yeah, bizarre, right? Maybe abusive discharge. Okay? We don't see cases like that, but maybe that would be an abusive discharge, and she can sue me for that. The other torts that we talk about or want to look at are fraud, all right? And here are the elements to fraud. Making a false representation with the intent to deceive, and the employee relies on that representation to his or her detriment. Okay? When we talk about fraud, it is making a false representation. And really of a material event. Let's go ahead and add that element in, because I guess I could make a false representation that didn't matter. It has to be a false representation of a material event. Okay? False representation of a material event or nature with the intent to deceive, and the employee relies upon that. Now, so last time when we were talking at the end of class about that situation where Amanda was moving to Chicago and came and saw me, okay, and I said, hey, I'll give you a job. Couple of things that's important. At the time that I make that representation, I have to know it's false. It is not false if I make it, but I change my mind later on. You with me? If I say, Amanda, we're not going to fire you, and in good faith, I believe we're not going to fire her, and then the economy goes belly up, okay, and then I fire her. That's not fraud. Why not? Why is it not fraud?
You were being truthful when you said it.
I was being truthful. Absolutely, Dave. I was being truthful when I said it. It has to be a false representation. All right, let's take this let's go a little bit further so I understand the basis of fraud in case I decide to ask about this. Say Amanda comes to Chicago and interviews with me, and I said, all right, here's what you're going to get, Amanda. You're going to work here for 5 years at least. We need you to come here, work with us for at least 5 years. In addition to paying you $50,000 a year, I'm going to give you a blue car, and I'm going to give you your health insurance and life insurance and disability benefits. All right? Now, Amanda comes out to Chicago. She works with me, and she has 5 years. She knows that. She knows she's going to get her 5 years. She gets her health insurance. She gets her disability, and she gets a green car instead of a blue car. All right? She sues me for fraud. Does she win? Jackie?
I wouldn't think so, because it's not like you're being really substantially hurt, or is it a material issue that it's
There we go.
blue and green?
There we go. All right. In my opinion, and by the way, this is a perfect example. I was trying to give you an example earlier, and this one will work, of where you can disagree with me on an outcome, and I don't care. I want the analysis, all right? If I were to ask you that question on an exam, all right, and you were to say yes, because in her mind, she wanted a blue car and blue was important. If you just say yes, she wanted a blue car and that's it, you're probably not going to get as much credit as if you say, yeah, she wanted a blue car and it is probable that she had a kid with blue eyes and that's why she wanted a blue car. All right? We're just making this crap up as we go along. Whoops, I can't say that. Sorry, Drew. But, yeah, the camera limits you. But as a practical matter, the answer I'm looking for is it's not material. The answer I'm looking for is what Jackie gives me, is that it's not material. But I will tell you this, if you tell me if the blue car was really important to her, I'm not gonna knock anything off because you and I disagree on whether it's material, as long as I know that you're thinking about whether it's material. Does that make sense? Yes? Shake your head yes or no. Okay, all right. So in that case, it's not material. You know, it may be. I remember once, gosh, I never, and in some cases you just remember. Had a gal, no, she wasn't a gal, she was 78, 80 years old. Bless her heart. And I agreed to represent her for free because my grandmother had done the same thing. They take advantage of elderly people, right? And they scamp vitamins, magazines, and you do this, you're going to win this. My grandmother spent, oh my gosh, thousands and thousands of dollars to these people toward the end of her life. But I had a lady who also did that, and they told her that she would win a car if she kept buying these vitamins, all right? They pretty much shut a lot of those businesses down. She came to me and I felt bad for her and kind of relived the situation with my grandmother, and I thought, yeah, I'll help her out. So I helped her out, free. Said, not going to charge you a dime. Ended up actually getting her a car. A car. And guess what? She complained because of the color of it. And it was like, really? Really? So that's why I think about the material. I guess to some people it is material. But you understand fraud. Has to be false representation, as Dave pointed out. Has to be false at the time you make it. All right? Has to be material, and it has to be something that they, with intention to deceive, and then it has to be something that they rely upon. Okay? Now, we also, another tort. So we have the tort of abusive discharge. I'm not real concerned about that one. You have the tort of fraud. Okay? You also have what is called the tort of defamation. The tort of defamation. What is defamation?
Talking bad about somebody's character.
Yeah, talking bad about somebody's character. All right? It's basically two types, really. Slander and libel. And I always get these wrong without looking them up, but go ahead. We'll pick on somebody here. What's slander? Dave? Yeah. Slander is written statements, all right? Libel is oral statements, okay? Slander is written. Libel is oral, okay? In order for there to be a tort, why is it a tort? Why do we talk about defamation as a tort? Why is that a tort? Knowing in mind what a tort is, why is that a tort?
If you have somebody talking bad or saying bad things about somebody, you can know their character and maybe potentially being hireable, getting another job.
Okay. Yeah, no, you're exactly right. If you're talking bad about people, and here's and we'll talk about a couple of things about this definition in just a second. But the key is, I have a duty not to spread lies about other people. Okay, it's just a duty that we've come out. Common law, all right. I have a duty not to spread lies about people. Here's what defamation really is: a false statement published to third parties. A false statement to third parties. If I go home and my wife and I get in an argument and she calls me a bunch of names, is it defamation? Say she calls me an SOB. Is it defamation? Why?
Because it's your base. It's not to anybody else but you.
All right, that's a safe answer, Tom. It's not to a third party. Why else? Go ahead.
Maybe you are being one.
Yeah. Okay. Thank you, Day. Thank you. Yeah. Maybe I really am. You know, I'll never forget. I came home one night, and my wife says, "You need to." I was cross-examining her. We got into a little argument. I was really good because she's not an attorney, you know, and I think I know this. And I was cross-examining her, and she said, "Come here for a minute." I said, "What?" "I want to show you something." And I said, "What?" And she said, "Come out here. It's on the front porch." So stupidly, I go out on the front porch and I stop there. And she locks the door behind me. And she says, "Now, when you can come home and be a father and a husband and not a lawyer, I'll let you back in." I was like, ah. But no, Dave, I appreciate that. Because if it's true, if I really am an SOB, all right, then it's not, you know, and that's an opinion. You also get to opinion statements, which is different. Tom takes the safe answer. It's not to a third party, all right? But defamation, what it is as a tort, is I have a duty not to share false information to others, all right? So defamation is false information published to third parties. Truth, as you've heard over and over and over, is a defense. So truth is a defense to defamation. Now, having said that, there are actually times that you can defame somebody, but it's privileged. All right? Let me say that again. There are times that you can defame somebody, but it is privileged. For instance, and it doesn't make any sense, but if you filed a lawsuit, you can say whatever you want in that lawsuit and it not be defamatory, even if it's untrue. Okay? There's just a privilege. There's a privilege for statements that are made within a lawsuit. Okay? Statements in judicial proceedings. I can file a petition and I can say lie after lie after lie and nobody can sue me for defamation because I'm doing it through a court. Okay? The other privilege is what we kind of call a business necessity or a business purpose, and here's how it comes into play in the employment. Even if it's untrue, if I communicate to somebody in a related business situation, all right, then I may be privileged if it truly is business related. Give you an example. If I say, who do I want to pick on? Jonathan, let's pick on you. Sorry. If I say that Jonathan is a child molester, all right? I have no reason to believe Jonathan, I hope you're not. And I have no reason to believe you are, all right? But if I say that Jonathan is a child molester, okay? And I've got a friend who's hiring Jonathan. They work at, what's the name of the child care here on Missouri State? Is it just Missouri State Child Care? Anybody know?
Is it Greenwood?
Huh?
Is it Greenwood?
Well, let's take Greenwood. Let's work with Greenwood because I know that. It's a school, yeah. Okay, all right. Let's say I have a friend who's the principal of Greenwood. And they come to me and they say, hey, Jonathan's just applied for a teaching job for the elementary kids at Greenwood. And let's say I didn't, that I really don't know Jonathan that well, but I've heard he's a child molester, okay? And I say to the principal, I wouldn't hire Jonathan if I were you because he's a child molester, all right? In that case, we'll say it's a false statement, okay? And yet that may be privileged. Why?
Because you're trying to protect the children.
Yeah, because I'm trying to protect the children, all right? Let's take that exact same example, but get out of Greenwood. Let's say that Jonathan is applying for work as a bean counter in the back of a bank. And all he is going to be doing is counting money at the back of the bank. And I say, Jonathan is a child molester. Is it privileged now? And you shake your head no, and you're right. Why?
There's no children around.
There's no children around. All right? Now, if I say he's a thief, maybe privileged. All right? But keep that in mind. That is a time where a statement can be defamatory and can be privileged. You can also have defamations in the employment setting where someone has falsely accused you of libel or slander. Had a case, gosh, it's been a few years. You have anybody from Stockton? We don't have anybody from Stockton here. I mean, I'm going to talk about this case, so it doesn't really matter. It's just Stockton had a huge tornado years ago, okay? I don't know if any of you remember that or not. But they had a guy who was in charge of cleaning up streets and stuff. and they weren't happy. The city of Stockton wasn't happy with the way the streets were cleaned up after the tornado. And I don't know if he did a good job. That was a horrible situation. They didn't have enough manpower, and probably, and I think knowing this guy, that he did the best to his ability. But they didn't like it. And you get into a smaller city type of situation, you got to have somebody to blame, and it was, let's blame the street maintenance guy, okay? And I say the street maintenance guy, the city maintenance supervisor. So the board came and basically said, we're going to terminate you. And he said, no, I'm picked up by the board, all right? I'm hired by the board, and you can't terminate me unless the board agrees that you're going to terminate me. All right? Well, the mayor said, no, we want him terminated. And he's, no, you're not. So we went to the board, and the board didn't terminate him. All right? That's in November, whatever year. It doesn't matter what year. In January, following January, 2 months later, the mayor comes to my guy and says, we're putting you on suspension. And my guy goes, why? Sexual harassment. Really? Who did I harass? And mentioned the gal's name, and we'll call her Tanya, and because that's her name. But mentions her name, and he says, when did I harass her? Says, last summer. Now, you with me on the time on this? November, they go to the board. January, they accuse him of sexual harassment for an event that happened before. Okay? Why didn't come up? You know, there was no doubt in my mind this was conspiracy. Well, we took it. We settled with the city. But, and for some reason, and we would have just gone away, the city didn't take care of the employee. All right? And when I say they take care of the employee, the city didn't make sure that there was a release between the employee that had accused my client of sexual harassment. So we had a case. We weren't just going to go away, and we tried a jury trial with this gal for defamation. It was pure defamation. You've accused my guy of something that's completely false. Tried it to a jury and got a verdict. You know, haven't collected a dime, won't, okay, because she didn't have any money. But it was just one of the principles of the thing, and I wasn't just going to drop the case because we'd settled with the city. But perfect example of she had gone and made these statements, and really what I think had happened was and we didn't go that far, but there was a conspiracy, my belief, my opinion, not fact, but we believed that there was some kind of conspiracy between her and some of the other people that wanted to get her off, and hey, you know, let's use this as a way to fire this particular guy. And so in your practicality, why do we tell that? It's important from when you get into administration or HR stuff and management, you want to make sure that you're not accusing somebody of doing something they didn't do, because you may get sued for defamation. What happened is, and I knew she was going to be very, very temperamental, she cried on the stand. And it was just really important to be as nice to her as I could. But where did he hit you? Well, he hit me on the buttocks. Well, which side? Well, you know, at one point we'd taken her deposition. In her deposition, it was the right. Guess which one it was? The trial. It was the left, all right? Well, you asked for time off for your birthday. It was your birthday, and you asked for time off. Yeah, well, did he give it to you? In her deposition, the answer was yes. At trial, we showed that she didn't clock out till 6 o'clock that night. So she couldn't have given, you know, you just built up lie after lie after lie, and we were able to eventually show, or the jury said, hey, she's guilty of it. And so you have to be careful about making false statements to get rid of somebody. And I've seen it happen time and time again. So in that practice, when you get in there in HR, you don't want to do that. The other part of defamation that you need to be aware of is what we call self-compelled defamation. Self-compelled defamation. And that's where the employee explains to a third party why it was that he or she was terminated, even if that reason is false. Okay? Now, attorneys representing employees, and so if you're into management, you got to make sure you're aware of this. But sometimes attorneys will ask for a particular reason as to why they were terminated, and then the employer may say theft. Okay, because there's what we call you have to have been at work with this employer for at least 90 days. Okay, so when we talk about a service letter, you have to be with the employer for at least 90 days before you're entitled to it. You also have to request it within 1 year from the time that you're terminated. And if you've worked, by the way, if somebody, just as a practical matter, if you've worked and you want to know why you were terminated and they say, we're not going to give you a reason, you send them a service letter. And if they're not a governmental entity, they have to respond. Okay? They have to respond. They have to tell you why, assuming you've worked there for that 90 days and you're making the request within a year. What will sometimes happen is the employee, let's go, Melissa's the employer. I'm the employee. I go to Melissa and I say, why was I terminated? I'm not going to tell you. So I send her this service letter request. And I say, now you got to tell me. Here's the statute 290.140 that says you're going to tell me why I was terminated. And you tell me. And she puts down because you stole something. Okay? Now, I then go to my next prospective employer and I say, hey, I want a job. And they say, why were you terminated? Go, here's the reason. And now I give them the letter that Melissa wrote. Why would I do that? Why would I do that? Because am I going to get a job? Probably not. Yeah. So why do I do it?
It might help to protect you from your maybe potential employer calling and getting a different story.
Yeah, but if I'm already theft, they're not even care. Melissa?
Are you going to sue the former employee for defamation?
Going to sue the former employee for defamation. Or I may not want to get a job, because one of the things you'll find out is with some of these cases, you have to do what is called mitigate your damages. All right? I can't sit back and say, couldn't find any work, or I can't sit back, not look for work, and then come back and sue Melissa because I've been without a job 6 months. All right? Because I'm sitting at home watching Oprah or Dr. Phil or whatever. Yeah, and I may do. Sorry for those of you who like Oprah or Dr. Phil. Didn't mean anything negative by that. But seriously, I can't sit home and watch TV and then say, hey, I've lost 6 months of damages or 6 years of damages because I've been unemployed, right? Court's not going to let me do that. However, if I keep sending out this service letter to every one of my potential employers, how many jobs am I going to get? I'm not going to get any. So now my lost wages stack up, all right? And by the way, you may think, really somebody would do that? Yeah. There are people that will do that. So you got to be aware of that. But also for that very thing, defamation. If I think I can really prove that I wasn't the one who was a thief, and I can get Melissa to put in a letter that I stole something, now I can sue her for defamation.
If that happened, that person stole something, would that employer have had to have charged them to have made it actual? Because otherwise,
Right.
if they didn't charge them, they are just saying, you stole something, but that employer didn't take any action.
Correct. But as an employer, I don't have, remember, and not that you have to write this down because this is not necessarily important, but there's a difference between a crime and a reasonable, and a civil action, all right? In criminal actions, you have to prove beyond what is a reasonable doubt, all right? O.J. Simpson, not guilty, supposedly, all right, because of what? Reasonable doubt of a crime. But he was convicted, or not convicted, but he lost the civil lawsuit because it's a different standard, all right? You don't necessarily have to file a charge or to the police that I've stolen property if you can convince a jury that I really did steal a property. And why, as an employer, may I not want to file charges? You accuse me of theft, all right? Why might you not want to file charges?
Enough money or enough to warrant the going through the attorneys.
May not be enough money. Okay. Time. What else? Reputation. Yeah. I don't want the publicity out there that I got people stealing from me because it makes me look bad. Okay? But that's defamation. And you can have it as self-compelled. It can be self-compelled. Okay? Any questions on that? All right. Another tort is what we call tortious interference with contract. Tortious interference with contract. In order to have tortious interference with contract, you need these elements. A valid business expectancy. Let me give them to you and then we'll go back and explain what they are. A valid business expectancy. Defendant's knowledge of the relationship. Defendant's knowledge of the relationship. A breach caused by defendant's intentional interference. An absence of justification. An absence of justification. And damages. Did you get all 5 of those? Or one more time? Because I don't think, okay, one more time. Let's just run through it one more time. A valid business expectancy, defendant's knowledge of relationship, breach induced or caused by defendant's intentional interference, an absence of justification, and damages. How does this tort play in the employment relationship or in the employment field? Where you see it the most is, and we'll talk about covenants to compete later on, but where you see it the most is in covenants not to compete. Okay? Briefly, don't want to spend a lot of time on it tonight because we'll discuss it in more detail. But what is a covenant not to compete? Somebody's come across it. Yeah.
It's whenever you sign a contract, like your employer, that you won't go to a competitive company.
Yeah.
After you leave.
Yeah, that's exactly what it is. If I sign an agreement with my employer, and mainly because they forced me to sign it, but says after this relationship terminates, I won't go to work with XYZ. So I've got an agreement with ABC that says I won't go to work with XYZ. All right? Now, I get fired or I leave. And we'll talk about the validity of that much more detail later on when we talk about covenants not to compete. But if I leave and I go to XYZ, and I go to XYZ and say, hey, I got this covenant over here with ABC, but will you go ahead and hire me? What should XYZ say? No. XYZ should probably say no, because they're just asking for a lawsuit. And frequently, when the employer sues the employee, the former employer sues the employee for violating the covenant not to compete, they bring in the new employer. All right? So as a practical matter, if you're out there hiring employees, you want to make sure that they don't have covenants not to compete. Because if you know about it, how's the business? Let's take these elements that we just went through and apply them to that particular situation. Employee works for ABC, leaves, goes to XYZ. What is the valid business expectancy there? Who has the valid business expectancy? Huh? ABC, and what is it, Day? You're right.
To protect whatever knowledge clientele is.
Yeah, to protect the trade secrets, to make sure they've got a business expectancy that their former employees will protect their trade secrets, okay? So they got a valid business expectancy. Now, defendant's knowledge of the relationship. Who are we talking about there? Keep going.
The XYZ.
XYZ, right? Okay. If they don't know about it, they can't interfere with the business expectancy of ABC. But if XYZ does know about it, they may be able to interfere with ABC. All right? And so they go, and here's a classic example. If XYZ would say to the employee, hey, I want to offer you $1 million to come and work for me. Okay? Yeah, but I'm not worth $1 million. I know you're not, but I hate the ABC so much, I want you to work with me. Okay? Then I'm willing to pay it. All right? There's the breach. That gets you into the third element of the breach. All right? The fourth is the absence of justification. This is a hard element to prove, and this is why a lot of times the employer XYZ isn't found liable, because they may have justification. What could justification for XYZ be in taking the employee? Anybody? What could be their justification?
They already have the knowledge of the job, so we don't have to train them.
Yeah, you know how to sell. I want you over here with me. All right? It's not that I have any desire to get all the trade secrets and stuff. I just want you working for me. Okay? I need another salesperson, and you're perfect for it. All right? So that's what you can get into. All right? So maybe the absence of justification. And then what are the damages? Could be the damages.
Whatever they grab from ABC, maybe a list of clients.
List of clients, lost business, absolutely. Okay, so that's how that tortious or intentional interference comes into play with that. All right, let's talk about a couple of other torts, and then we'll kind of try to wrap this up with a couple of things. A couple of others. Negligent hiring. Any idea what negligent hiring is? Or negligent retention. When we say retention, what do I mean by that word? Retention. Keeping. Okay. So if I've got negligent hiring or negligent keeping of an employee, how would that be a tort? Let's say I work in a daycare. And I run a daycare, all right? And I go and I'm hiring people for that daycare. And I have an employee that comes to me, and what is the first thing I'm going to do when an employee comes to me if I work at a daycare, I operate a daycare? I'm going to do a background check. We'll talk about background checks later on. So let's say I get this background check, and I go, you know what? This person has been convicted of child molesting. We'll go back to the child molesting example, all right? This person has been convicted of child molesting in 3 different states, all right? If I hire him, can I be sued? I can be sued for anything. Can I lose? Absolutely. I had a duty to the parents of those kids, more important, to the kids themselves, not to hire somebody that was going to put them at risk. I hired him, so that's either negligent hiring or I kept him after I found out about it, and that's negligent retention. All right? So that's what we call negligent hiring, negligent retention. You can also, where you also get this tort action in the employment law area, is torts by co-employees. Okay? Torts by co-employees. What do I mean by that? Anybody? How could torts by, or how could co-employees be a tort? What could co-employees do to each other to be a tort? Harassment. Or let's be even more blatant than that. Physical assault. Okay? If I've got Tom and Kyle beating up on each other, all right? Either one of them could sue me as the employer for allowing that to go on, all right? Or they could sue each other, at which point I may be liable. Your book, or there's a term out there in either the book or in the supplementary materials talking about joint and several liability. Remember what that is? Melissa?
You could sue one or more than one.
I can sue one or more than one, and any one of them could be responsible for all of the action or all of the damages. I'm sorry. It's a lot easier to explain in a car wreck situation, okay? I've got 3 people that are following too closely. You get the chain reaction, but they're all following too closely. I might be able to sue any of them. Or I run a stop sign, 2 people run a stop sign at the same time, okay? There may be what we call there, okay? Any question on that? I don't want to spend a lot of time on it, but basically where you have joint and several liability. The other liability you need to be aware of is vicarious liability. And that's where an employer is liable for the torts of its employees. We had a case, it actually took it over. A guy, one of my favorite clients of all times, was a work comp investigator going down the highway at 5 a.m. in the morning up on 71. And he was driving. All of a sudden, the car in front of him, he didn't know there was a car in front of him. The car in front of him just a few minutes before had hit the guardrail because the guy had fallen asleep. And then came back into the road, but with all the lights out. I mean, killed the battery or whatever, so there's no lights on there. My guy is going down the road, just hits the car, maybe sees it at the last second, puts on the brakes, but hits the car, tears up his leg, and as a result ends up having a below-the-knee amputation. So, I mean, we're talking about a serious situation. I didn't represent him at the time. Somebody else was, I won't say who, but somebody else was representing him and basically told him there was a work comp because he was actually on his way to investigate. So there was a work comp. But in work comp, if you get money from work comp but sue a third party, work comp gets paid back a portion of that. Okay, I may get more detail on that later on. But anyway, they settled. They were working on the work comp aspect of it, and the guy said, well, okay, so we're ready to settle your third party. And he says, the client said, well, what do I get on my third party? You know, and he goes, well, we're going to settle for $50,000. And he goes, 50, that's it? And he says, yeah, that's it. And by the way, after I pay off work comp and after I take my attorney fees, there's not going to be anything left for you. So, and guess what? He wasn't real happy with his attorney. He came to me and I said, look, I'll look at it for free. And then if I can get you, if I can't get you any more, then you're not out anything. And but I think I can get you some money on this case. And I think we can help you out on the work comp. And we ended up finding a doctor in Oklahoma who was a prosthetic doctor. The reason I love this client, he's an ice climber, with one knee. I mean, he makes the best out of the situation. But as I was going through the file with him, I said, Chad, tell me, I know why you're on the highway at 5 o'clock. But why is a guy from Alabama on 71 at 5 o'clock in the morning? And he explains to me that he didn't know. He asked his attorney. His attorney never found that out. So we sued the guy. I said, we'll just sue the guy. We'll take his deposition and find out. Turns out, and this is where you get into vicarious liability, and as a manager, you have to watch out for this stuff. Turns out that he was actually on his way to Kansas, that he was working. Now, former attorney didn't know this. Here was the end result, positive for us, is that the insurance company for his employer actually had a $2 million policy. And we were able to settle the case for $1.6 million when he was looking at 50 at one time. The key to that is, why is the employer responsible? We talk about vicarious liability, and that's where this term goes. Why is the employer of the guy who hits the guardrail responsible? Jackie.
He was in the realm of his employment whenever the accident happened.
He was in the rim of his employment when the accident happened. Okay? So while he's doing stuff, once a person is in the rim of the employment, of their employment, the employer can be held liable. Okay? Right or wrong, like it or dislike it, it's a tort that you have to, or action that you have, the theory of liability that you have to be aware of. So when you get out there and you're practicing in this area of administration and management, you want to make sure as a supervisor that your employees are doing everything they're supposed to be doing, because if they're not, who does it come back on? It comes back on you as the company, or may even come back upon you as the supervisor. Okay, generally not, but you have to watch out for that as a supervisor. All right, one of the questions that we saw, and by the way, if I don't answer them and you want them answered, I'll try to answer them, but make sure you send me another email or I'll go back and look. But one of the questions that we got was bullying. Why aren't there more laws against bullying? Because I think your book talks about the fact that they try to do it, but nothing happens. There are actually, over the last several years, 21 states that have tried to implement bullying. Why didn't an employer want, and none of them have passed, or very few of them. I don't think any of them passed. But why wouldn't an employer want, why the fight against bullying?
Such a fine line. Like,
Okay, Anna?
it's hard to justify what bullying is.
Yeah. One, it's hard to justify what bullying is. All right? Why else doesn't an employer want it?
So you can get, like, for anything.
You can get sued. Right. And so now if they've got another law, that means they can be sued. Here's where I think you're going to see it, and I think you'll see it, I say in your lifetime, that's a long time, but I think what you'll see, bullying is the key. I've been to a couple of conferences lately. Bullying is one of the top topics out there right now. And particularly, and you still see it in the school. What's the latest example that we've had of bullying made all the news?
The old lady on the school bus?
The lady on the school bus. Absolutely. All right. The lady. Now, it wasn't her employer bullying her, but all of this bullying stuff is coming more. Where else do you see bullying that has been in the news? The lady in the school bus, perfect example. Where else?
Like on
Facebook. There you go. It happened right here in Missouri, right? The girl hung herself because her mom, you got to wonder what kind of person the mom was. The mom of this were they in cheerleading? Is that what they were? They were some kind of competition, and the mom of the competitor like pretended to be a boyfriend of this girl and then dumped her and said all these horrible things. I mean, it was really a horrible situation. But your school right now, but you're going to see it in the employment field. And so you need to be aware of that, and you probably ought to write policies for that if you become into the employment sector, and you look at policies on that. All right. Any other questions with regard to that, and bullying or anything else? Okay. Let me just ask a couple of questions just to kind of make sure that I understand where we are. Is the employment at will doctrine generally based on state statutes? True or false?
True.
How many say true? How many say false? Okay. Probably not. Unless there's specific statutes out there. Now, there are exceptions that are based on statute, but the employment at will itself is not based on state statute. Now, that's what the Model Employment Termination Act, which hasn't been passed in any state except Delaware, right? Montana may have its own law that specifically, I think the book or supplementary material may talk about Montana as having accepted the employment at will. But for the most part, the employment at will is not a state statute thing. When an employer and employee have agreed to a specific period of time, neither party has the right to terminate the relationship arbitrarily. True or false? When they've agreed to a specific period of time, neither the employer nor the employee, they've entered into a contract for a specific period of time, neither the employer or the employee have the right to terminate it arbitrarily. True or false? Tom?
Generally stated, true.
True.
Unless there's otherwise stipulated.
Yeah, and the key there is probably arbitrarily. Yeah, they don't have the right. Because why? Why is that generally true?
Because they agreed to a certain amount of time.
They agreed, which makes it an exception under what term?
Contractual.
It's contractual exception. Okay? It's simply a contractual exception. Let me ask you, which of the following might protect an employee under the public policy exception? All right, we're going to talk about the public policy. We've talked about that. Which of the following might protect a protect an employee under the public policy exception. Performing a statutory obligation, refusing to violate a statute, or reporting an alleged violation of an important statute, or all of the above. All of the above. Okay. All of the above. What makes the difference? Regurgitate back to me so I can make sure we understand. What's the difference between a statutory exception and a public policy exception?
Statutory, there has to be a specific law.
Statutory, there has to be, absolutely. Statutory, there has to be a specific law that says you can't terminate the employee. Okay? Whereas you don't necessarily have to have that for the public policy. You still have to have a law, but not one that says you don't fire them. Okay? All right. Having said that, any questions? That's the employment at will. And the tort stuff. Any questions? Any other questions about anything that we've covered tonight? I'll try to get on Blackboard tomorrow, assignments, questions on Sunday for the next, what we're going to talk about. I think we get into privacy. I think we're going to talk about privacy issues next week, but I'll let you know first thing in the morning. Okay?